of this session. My name is Francine Ryan. I'm a module team chair of W360 and one of the academics in the law school. And I'm delighted to be joined by a double act of Simons, so Simon G and Simon C from CILEX, who are going to talk a little bit about the routes into the profession and how to become a CILEX lawyer. And then we're going to move on to talking about a very interesting recent judgment that CILEX have been involved in called Mazur. And Simon G is going to give us some perspectives about why they took this case on, what was involved, and share his experiences. So we've got a Q&A function. So if you've got questions, please feel free to pop them in the Q&A as we go along, and then we will have an opportunity to ask questions. And if there are particular questions that come up when the speakers are talking, I might also ask some of those additional questions. So please feel free to pop those in the Q&A. That'd be great. If you could put the questions in the Q&A rather than the chat, it just makes it a little bit easier for us trying to manage sort of both things going on at the same time. So be really grateful. But John Paul and I will be kind of keeping an eye on that. So I'm delighted to hand over to Simon C first of all, and he's going to talk a little bit about removing barriers to the legal profession, the CILEX graduate qualification. Over to you, Simon, and thank you so much for coming along today.
Fantastic. Thanks, Francine. No, you couldn't have kept me away. This is a highlight of my calendar, as I've said before. Being an OU alumni myself, I studied for my own LLB with the Open University, and it's opened some incredible doors for me. So yeah, always a pleasure to come back and do this. So I will just flick through here. So firstly, just for anybody who's unfamiliar with CILEX, I only ever found out about CILEX at an OU Careers Day. So we are the Chartered Institute of Legal Executives. So there's three main disciplines of lawyers, of course, solicitors, barristers, chartered legal executive lawyers, or CILEX lawyers. So we're a leading awarding and professional membership body. So we're not only a membership body for our members, similar to the Law Society, but we have our own awards. We train our own lawyers as well through regulated qualifications. We have our own regulator, CILEX regulation as well. And throughout this as well, we offer career-long professional development. We support around about 18,000 plus legal professionals across England and Wales, and indeed across the world in actual fact, because there's a lot working in British colonies as well. So just in terms of who we work with around about 70-75% of the top 200 UK law firms across England and Wales. So you'll see a few there, but it's not only law firms that we work with, everybody from the magic circle firms right down to the high street practices and everybody in between, but also large retail organisations. You'll see Tesco there. And a lot of government agencies, the Met Office, Home Office, Crown Prosecution Service, HMRC, as you can see there as well. So the CILEX lawyers in multiple areas of the legal sector. So a quick overview of the qualifications. So the qualification is the CPQ, or the CILEX Professional Qualification, and it's ordinarily a 3-tier qualification. However, unless you have a law degree, and very specifically an Open University law degree, that enables you to skip the first stage, the foundation stage, because we don't make you repeat that content. We take into account the study that you've already done and will exempt for the study that you've already done. Once you've proved yourself proficient in that area, there's no need to do it again. So what that means is that having an OU law degree under your belt means that it's going to be a more fast-tracked journey to getting to become a CILEX lawyer. So we have the suite of CILEX graduate qualification options there. So you may decide, or you may well be working in maybe employment or immigration or maybe commercial. You may be working one of the litigation areas, so civil litigation through dispute resolution, criminal litigation or family practice, or you may choose to go into property or probate. So there's multiple different pathways that are available. We say pathways because it differs quite a bit from the SQE, which I'm sure many of you will be familiar with, in that CILEX lawyers choose their specialism early on. So the advantage of this is that it means that you can streamline the qualification. It means that you don't have to cover quite so much ground in terms of the different subject areas. So we concentrate on showing proficiency in at least 4 different practice areas, so it minimises the amount of superfluous study that you have to do and concentrates on the area that you really want to focus on and that's really going to add value in the long run. So qualifying as a CILEX lawyer with an open university law degree, so that's the starting point. So having the LLB under your belt means that you could then move on potentially to graduate stage 1, complete that stage, move on to graduate stage 2. But whilst you're doing that as well, we always recommend building up some experience as well, because you're going to need qualifying experience in order to qualify as a lawyer. It's very much like if you were a junior doctor or somebody training to be a surgeon, then effectively you'd want that safe environment in which you could make mistakes and nobody suddenly flatlines. So it's going to mean that getting that qualifying experience means that you will be able to show the regulator once you have finished that you're a safe bet. They're safe to award you the ability and the rights to practice independently. And with CILEX, that's 3 years. And that can be for the first year, you can be working in any capacity, just as long as you're working in a legal sector profession. The next 2 years of that 3 years should be in the area in which you're seeking to qualify into. So let's say, for example, you work in property, then you'd concentrate on building up that experience in property so that you would then get your property practice rights at the end of it as well, having submitted your portfolio of evidence to qualify. The same is for litigation as well. So it's really just getting that real boots on the ground experience as well. So for that reason, we always recommend gaining yourself a foothold if you're not already working in a legal sector role at the moment. Do ask us any questions about that if you do need any ideas on how to secure legal employment. So if you were looking to qualify in civil litigation, now looking at this, because I understand that OU nowadays slightly different to when I studied, there's 3 different iterations of the LLB. So there'll be those of you that are doing the academic LLB, is it free choice, Francine, LLB as well? So
yeah, I'm gonna just defer to Liz just so I don't get things confusing
on
that.
Yeah,
but yes.
Yeah, so when you study the same at levels 1 and 2, first and second year, the third year you have to choose a pathway. There's 3 pathways. One is the SQE pathway for those looking to take the SQE exam. One is the Foundations of Legal Knowledge pathway for those wanting the 7 traditional subjects to become a barrister. And then the third is the academic pathway. You have to do 1 compulsory module on that pathway, but then you have free choice for the other 3 modules.
Excellent, that's ideal. So basically looking at here for the this will be for the functioning legal knowledge degree and for the one that the last one that Liz mentioned there as well. So it would look something like this. So basically the graduate stage 1, we recognise that you've already studied criminal law, so we don't need to get you to repeat that aspect of it. We just get you focused on the practice side of things, criminal litigation in working in criminal practice. Introduction to Property and Private Client covers probate practice and conveyancing, because you'll have already done land and trust as part of your degree. And then the main thrust of your studies would be around dispute resolution, civil litigation. So there's a professional skills project, a written project at the end, very similar to an EMA. That is based on your own team within the workplace as well. So that's a really good opportunity to get an understanding of the nuts and bolts of your organisation. You'll also see the optional advocacy course there. So completing and qualifying through this route would give you civil litigation practice rights, enabling you to conduct civil litigation matters independently. The advocacy course is a bolt-on that just enables you to be able to advocate for clients in open court, should you choose to, as well. So we'll look here. Here's another example of those of you that would look to qualify into property. So in this case, residential conveyancing. So again, we've got the core practice areas there as well, working civil practice this time, working criminal practice, introduction to property and private client. And then again, the main study is going to be around residential conveyancing. And again, for family practice, similar in that the main stuff is going to be on family practice, and again the optional advocacy course there. Completing that pathway will give you the right to work on family litigation independently. Now, for those of you that are actually looking at the SQE pathway as well, it's significantly more in terms of exemptions. So basically, it could be as much as 4 exemptions, depending on the practice area that you choose to go into. So that does minimise the amount of study that's required. It also minimises the cost as well. So it does really sort of cut that down. We've worked with OU to map our qualification against the LLBs as well. So we're confident that the modules are so robust that it covers our content, and there's no need to repeat it as well. So for anybody looking to qualify into family practice, if you've taken the level 5 family law studies and elective, then in which case then it would be quite significant exemptions there as well. So in terms of the structure of the program as well, so our assessments are taken online. So we have January and June exams, and it's really centered around how quickly you want to get through it. That's really up to you. So typically, those training through CILEX qualifications would do around about 7 to 8 hours of study per week. So slightly less than I recall putting in for my OU degree, but certainly, it can be spread over a longer period of time. It can be condensed and studied in a shorter period of time as well. So these are designed as earn as you learn programs as well. So they are designed to be fully fitted around full-time work, and indeed 75 to 80% of our qualifications, depending on the time of year, are funded by employers as well, because they recognise that it works well as a work-study balance rather. So in terms of our the way it's structured, it is modular assessments. So that means that once you've passed an exam in a particular area, that pass is banked. Nobody's going to take that away. There's no running out of time or and then losing the ability to and then having to resit it because you've run out of time. It's nothing like that. It's literally like Lego. You put the qualification together as you pass each of those different elements. So it's a very varied assessment methodology as well. So there'll be some of our exams that will be predominantly multiple choice, similar to the SQE, but very different in terms of the answers as well. It's not single best choice answer. They are very distinct answers as well. There'll be some with practice-based scenarios that will reflect the sort of work that you're likely to do in practice each day, and they are centered on the generally on single subjects as well, so it really allows you to get deep into the subject matter and really get a feel for it as well. So very much future focused learning as well. So it helps you develop commercial awareness, technological insight, essential soft skills, and it really just teaches you all the full skill set outside of just the law and practice as well. So it's not just that that we're teaching you, so much more to being an accomplished legal professional than just knowledge of law and practice. We don't put a cap on resits either as well. We recognise that some of the best lawyers are not necessarily those that can hold it together in exams. So it just gives you that added flexibility. And in terms of our pass rates as well, our pass rates are session on session, sort of 80%, 90% in some cases as well. So and that's just down to the way that we assess it, the way that we structure it, and the fact that we generally concentrate on single subject exams as well. So just very, very conscious of the time here. Unfortunately, I've just spotted a typo, which is unfortunate. But there are significant exemptions from the graduate qualification dependent on your practice area as well. I can answer any questions on that as we go through. So just a quick bit on qualifying experience. With CILEX, you need to be able to evidence 2,300 hours worth of qualifying experience, and that is work that supports the provision of legal services and supervised by an authorised person as defined by Section 18, the Legal Services Act 2007, which I'm going to segue very nicely in a second into what Simon's going to talk about as well. So yeah, works quite differently to solicitors training contracts, which is where you would ordinarily do multiple seats. What we're actually training you as specialist lawyers, so it really benefits you to have that that time really spent learning your trade in a particular area. So final bit from me in terms of membership as well. So CILEX membership, we are at our heart an award, a membership body. So CILEX membership, you don't need to be studying with CILEX to be a CILEX member, but it can give you this sort of professional recognition and the sort of moniker, if you like, in terms of if you're going out there, the legal identity, if you're going out there seeking employment, employers recognise that you are serious about being regulated by a professional body, that you are serious about aligning yourself with a professional body as well. So anyway, there's a couple of bits more, but I'm just going to hand over to Simon now because I'm really conscious of time and I want to make sure that we've got enough time to go through everything. So
thank you very much. And would you be happy to share your
Absolutely.
Slides afterwards? Brilliant, thanks very much, because we have a request for those. Fantastic. And as Simon says, that very nicely segues into our other Simon, who's going to talk a little bit about kind of what's been in some interesting times, haven't we, Simon, in relation to the very precise interpretation of what words mean in statutes, which we all will teach our students around all that. So, but you've been really at the heart of all of that. So tell us about kind of Mazur and what's been involved in your involvement in all of that.
Happy to do that. Thanks very much, Francine. Thanks, Simon. Yes, so it's looking back, it's hard to believe it's only been about 6 or 7 months since the original judgment that happened in, I think it's in September, the judgment in first instance in the Mazur case by Mr. Justice Sheldon. And it's probably true to say it sent shockwaves through the sector, actually, everywhere. We'll come on to why as we go through this. And we successfully appealed that judgment. That judgment was handed down in March. And you might think, well, why? You know, what was the deal here? Why did it create the waves that it did, and why did we get involved? So I'll talk a little bit about the background to the case and, you know, what happened and why we got involved, and just what those shockwaves actually were. I mean, on the face of it, you wouldn't think this would be something that would create the waves that it did. This is all about legal regulation, And specifically, it's about those 6 reserved legal activities under the Legal Services Act. That's conveyancing, probate, litigation, advocacy, acting as commissioner for oaths, and notarial activities, if I can say that, as you probably know. But the jeopardy that hangs over those, I suppose, since the Legal Services Act in 2007, is that if you conduct any of those reserved legal activities without being properly authorised, you're committing a criminal offence. So getting it right, understanding that dry old regulatory piece in reality is really important. And the Mazur case was about the conduct of litigation, which over the years has itself, actually, of all of those 6 reserved areas, been itself the most subject to litigation, not least because it links to costs. In other words, if you do something that you're not authorised to do, it's possible to take cost points against it. You could refuse to pay the costs. You could challenge the costs incurred. And that's why litigation in and of itself has got quite a bit of case law associated with it over the years. But the interesting thing for me, and I was one of the people who was involved in trying to getting together our submissions for our Court of Appeal case, is that actually conduct of litigation has been regulated in that way for centuries, actually. Most of the time, though, that's been as a monopoly. So solicitors were generally the only ones who could conduct litigation. But it was only a sort of, I can't believe I'm talking centuries already, so do give me a nudge if you glaze over. But by the time we got to the 20th century, I think Parliament was looking to catch up a bit with modern practice, and so consciously started introducing legislation that was going to sort of modernise a bit. And the first bit of legislation that altered that solicitor monopoly on the conduct of litigation was the Courts and Legal Services Act. And the one that we now have, the main piece of statute that we now have, of course, is the Legal Services Act of 2007. And what that act did was to take, well, it tried to take all the pre-existing bits of statute and wrap them up together and put them in a schedule of the Act, and essentially create a framework in which other different legal professionals other than solicitors, and of course I'm thinking here, of course, about chartered legal executives in particular, could acquire the rights to undertake those reserved legal activities once they've done so in the proper way. And the whole idea, and this came out as part of our appeal argument, of course, was that the will of Parliament here was to open up the market. It was to get other lawyers involved. It was effectively expanding that supply of lawyers who can do this work, and the idea of that was that it would increase access to justice. But all those years while it was just done by solicitors, it was very common that solicitors would delegate their work around conduct of litigation to non-qualified people, and those people would be doing that work for them under supervision. And actually that's the sort of model that still exists. I mean, CILEX members, 75% of our members work for SRA regulated firms, and so that pattern of working under supervision, if you haven't acquired your own rights, your practice rights to do those reserved activities, is still a model that exists. But over the years, no one was particularly bothered actually about that arrangement, because it was being done under the context of within the context of a solicitor's firm, and I guess the presumption was that solicitors, they are authorised to conduct litigation, they're overseeing that work. So supervision, if you like, was implicit in the confidence people had that it was being done all properly. And as a consequence, there's nothing in statute, or there has been nothing in statute about any express provisions that permit that delegation to non-authorised people to conduct litigation. And all was apparently working well without that level of detail in statute. And in actual fact, there was an opportunity to clarify that when the Legal Services Act was brought in 2007. And within the schedules of that, you will find express provisions that talk about delegation of activities, but not about the conduct of litigation. An omission, I think,
if only.
we came to rue the day on that lack of detail, because that lack of detail, what it meant was really that there were two views that began to emerge. One was, and of course, if you were growing up in practice as a lawyer, doing this work, seeing case law and legislation come along, many people just thought, and this was the school of thought, nothing has changed. The Legal Services Act didn't change anything. You always have been able to, and you can continue to delegate conduct of litigation under supervision to non-qualified people. But the other school of thought, if you like, that began to get a bit of traction was that actually, because the provisions of that act don't have any kind of express provision around conduct of litigation, well, then maybe you can't delegate to an unauthorized person under supervision. And what we saw, and actually CILEX was part of this environment too, so we hold our hands up there too, is that guidance that was put out in the sector by various bodies varied. I think everyone was interpreting the rules and the regulation, the legislation in good faith in the best possible way, but it just wasn't clear. And even the SRA's effective supervision guidance, which was kind of go-to for many in the sector, took a slightly different view. So there was no kind of universal view of what the actual law was, and the difference in those interpretations is the thing that caused the Mazur judgment, or the Mazur case. And the Mazur case, going back to my reference to costs earlier, was essentially a cost dispute, and Mrs. Mazur essentially was disputing her solicitor's costs, and that solicitor's firm delegated the recovery of those costs to another solicitor's firm, and the person who was doing that work didn't have a practicing certificate, and therefore wasn't authorized by having a practicing certificate. And Mrs. Mazur took the view that the work that person was therefore doing was unlawful because he was unauthorized, and therefore they could recover the associated costs. And actually, so this was appealed in the first instance, as I say, before Mr. Justice Sheldon, and he immediately understood the real sort of public interest, I suppose, or the need to try and get some clarification here. And he, as happens, he invited the Law Society and the SRA to sort of intervene and make some submissions around it. But he didn't ask CILEX. We didn't hear about this, which is unfortunate because, as I was saying, so many of our members working in SRA regulated firms and elsewhere under supervision were impacted by this. At the very least, it created uncertainty. At the worst, it created, well, I'll go on to the other impacts that it had. So this was definitely a reason for us to think about, if we could, getting involved, because it was such a fundamental effect on our members. But anyway, Law Society and SRA took the second view. In other words, that you couldn't delegate litigation to people under supervision, and therefore the judge thought that was the right decision. I guess we can have no qualms with that, really. I mean, as the Court of Appeal itself went on to say, that decision was totally understandable given what Mr. Justice Sheldon had in front of him at the time. In other words, he probably didn't have the full picture. He didn't have the full amount of assistance that he could have had. I'm not saying that CILEX could have ridden in a blaze of glory and at that point, but certainly missing some key perspective on people actually doing the job in the sector. So yes, the decision was you can't delegate the conduct of litigation. This created lots of sort of, well, at a top level, it really focused on that jeopardy point I mentioned, that if you are straying into conducting litigation and you're not authorised, it's a criminal offence. It also meant that those costs points that I mentioned could be taken, and that certainly happened. And it also had a real regulatory kind of impact, because of course if you're doing something wrong, the regulator has got to react and step in. But in a sort of really practical sense, at a firm level, really unhelpful and confusing for many firms, because, and some of the case law talked about this, you could find yourself in a situation where you were undertaking work, you've got teams of people undertaking work, and at some point on that spectrum of tasks that you were undertaking, you may trip over a threshold that means a threshold that's not defined, by the way, that means you're conducting litigation, and if you're doing that unauthorized, it's a criminal offence. So it made a lot of uncertainty for firms, and being inherently cautious, it caused firms to stop doing lots of things, which itself, created delays in processing cases and in courts and so on. Also, there was a whole rash of cost cases that popped up. One of our legal team was saying that he understood, for example, in Birmingham, they had their own special judge appointed just to deal with all the cost points that then arose following that Mazur judgment. And so, other impacts, I'm just going to try and toggle across to my other crib sheet here. I mean, we were seeing quite fundamental things happening to our members. So certainly many of those who had practice rights and working as sort of criminal lawyers, criminal duty lawyers, their firms were suddenly really uncertain, given the judgment, whether they were suitably qualified, even though they were, and started taking case files from them pending them getting another qualification or getting that clarity. So case files were being taken away from members, not just in criminal firms, but other firms too. We were seeing delays at court. So if there was a chartered legal exec or a non-solicitor or barrister in the team, there was lots of questions around the status of that person, what they're qualified to do, what their contribution to the case actually was, which made delay. There was also different interpretations. We were told by people, for example, that the judgment seemed to contradict certain parts of the civil procedure rules, which seemed to say another thing in respect of people who were employed by solicitors' firms. So we were seeing our members who were classed as grade D fee earners in civil cases suddenly told, well, actually, no, you can't be doing that. From the CILEX point of view, we also saw students now uncertain about what qualifications we offer actually enabled them to do. So there's that kind of question hanging over that, and some of the impact on those cases, the sort of delays I mentioned, were quite often in the most sort of sensitive areas. We were seeing lots of local authority work, family and children cases in particular, court protection cases, all of a sudden were being stopped, mainly because teams of chartered CILEX lawyers in firms were having work taken away, and were quite often driving that sort of transactional process work in local authorities and elsewhere. And also lots of uncertainty among the insurers, and of course you want to make sure that you're properly insured when you're doing this work, and the insurers are suddenly uncertain. So, and I think we spoke to you, Francine, and colleagues about the whole situation around what does that mean as a trainee lawyer? What can you do in terms of qualifying work experience now? And it certainly felt, and I think CILEX felt this too, that there wasn't sort of sufficient focus on this kind of detail from the regulators. The SRA and the Law Society were really happy with that Sheldon outcome. The Legal Services Board, the oversight regulator, who were looking at, should be looking at the consistency advice in that area, they were happy with it too. The general view from that school of thought was, well, nothing's changed. All that judgment did was to confirm the law. And if actually there are problems for lawyers in practice, there are remedies. You can get other qualifications. You can come to CILEX, like Simon was saying, and get your practice rights, for example, and get authorization. But whatever the academic position you took on that judgment, as I say, the sector was reacting. It was actually doing things differently, and our members, case files taking away, some were losing their jobs, some were subject to demotion. In other words, they were appointed to do one thing and then told, well, actually, we're not confident you're qualified to do it. So we started to agitate and question this acceptance of the judgment, and frankly, we were told just to go away and get on with it. It is what it is. But we felt, because we hadn't had our opportunity in court, both at that Sheldon point and over the years in various bits of case law, that this needed challenging. It was the wrong decision, and we felt the court hadn't had the right arguments in front of it, because we weren't part of that case, part of that judgment. We were really fortunate that there are other lawyers in the sector who, as a matter of principle, felt the same. In other words, felt there was something wrong here. There was something wrong in sort of customary practice and understanding about what was permitted that had been completely undermined. And we were also fortunate that those same lawyers of principle were prepared to act for us pro bono. So I'm talking here about Ian Miller and Stephen Nelson from Kingsley Napley, and from 4 New Square Chambers we had Nick Bacon KC, Helen Evans KC, Faye Metcalf and Teen Dewey Chow, who were part of our team in the appeal. Of course, we weren't party to the case at first instance. We were worried we wouldn't actually get permission to appeal, but we did, and actually they also acknowledged our request to expedite this. Interestingly, talking to all and sundry in the sector, there was a real feeling this had to have a second go. Yeah. This had to get sorted out. I mean, talking to the judiciary, for example, they were really, I think, frustrated with some of the delays and some of the confusion here. So I think there was a bit of building momentum that there had to be a kind of another go at this, and that's why we, managed to get permission there. And we were joined, of course, by others. We were joined by the Association of Personal Injury Lawyers, who were part of the cohort solicitors most affected because of their business model. They felt that that business model was challenged. It was based on a model where you've got teams of supervised individuals conducting the work because it's high volume, low value work. So if suddenly you've got to change that ratio of supervised people to authorized persons, well, suddenly your cost model could potentially go out of the window. And of course, also joined by the Law Centres Network for a similar reason. I mean, that's how Law Centres networks work too. They have teams of supervised persons doing that work. Actually, a lot of them, some of them have legal aid contracts. So there was a real prospect that, as happened in Suffolk, I think, that there was no legal aid provider for a time in Suffolk because the Law Centres Network was it for certain cases and had to stop doing the work. So there's real kind of public interest reasons to revisit this as well. But we, on the other side, rained against us, as I say, it was the Law Society, the SRA, and the Legal Services Board, who all wanted to keep that original judgment upheld and actually were quite aggressively pushing that line. But fortunately for us, it went our way. The court did decide that the proper construction of the meaning of the carrying on the conduct of litigation meant that non-authorised persons could conduct litigation under supervision. So even saying that, you can see how some of the confusion can arise. That sort of the differentiation we were making was between carrying on the conduct of litigation and the conduct of litigation. And carrying on, we argued, carried with it some responsibility and accountability. So you could conduct litigation, but the person who was supervising you was the person overall carrying on the conduct of litigation and effectively accountable for that work. So the first instance judgment was wrong, and we seemingly had got what we want. Well, we did. We actually it went our way, and of course that helped with the problems I mentioned earlier, because although that criminal offence point still is there, of course, that only arises if someone who's not authorised is actually conducting litigation. And now that clarification meant that it was a lot clearer that where people were doing the right thing and not as hazy as the previous judgment had allowed. And also, I think it set the bar fairly low. The Court of Appeal did, because it's quite difficult to think of any circumstances, certainly if you're working for a law firm as an employee, where you're not actually doing work on behalf of someone in that firm. And I think that was a recognition of the practical impact of this, and that's what the Court of Appeal wanted to rectify. And also it means the costs issue to an extent went away as well, because again, really difficult to mount any challenge in relation to costs based on a criminal offence having taken place if a criminal offence actually hasn't taken place. So yes, it was quite a journey, the whole appeal process. I think many people now think we're back to where we were before the Mazur judgment. I mean, I actually think we're probably in a bit of a better place than where we were before. I mean, there isn't any longer that dispute on what the law means. There's two schools of thought: you can and you can't. There's also, from a regulatory point of view, it really means that conduct of litigation shouldn't be treated any differently from any other reserved legal activity. And also, I think it also pointed out that as long as the firm is regulated and as long as those supervision arrangements are real, demonstrably real, if a regulator asks what those arrangements are in place, then things can carry on as they have been. And it's quite handy too that the appeal has thrown the light on what does proper supervision mean.
Yes.
And the Court of Appeal also made the point, and it referred back to what Parliament originally intended with this Legal Services Act, was that, you know, it's important that the sector can function, that the sector can be opened up. But actually there is recourse if things go wrong, and predominantly that recourse should be regulatory. And so what's going to happen now will be quite interesting, because the expectation is that where everyone was trying to make some understanding of the varied interpretations of the law, now the expectation is that all the regulators and ourselves as professional bodies will work together to be much more consistent and have a shared understanding. I know the Law Society broke cover first on that, so I don't know if anyone's seen the Law Society put out some guidance first after that appeal judgment. I think they've revised it slightly since. We did make a few comments about it. I know that the SRA and our own regulator, CILEX regulation, has got some guidance coming out imminently. So I think, quite honestly, we will see an improvement there in terms of clarity, but I suspect because this has shone a light on this type of work, these sorts of discussions about what it all means and what it means in practice will probably run on a little bit, which is no bad thing.
Yes.
Because, you know, the law does evolve and different scenarios arise, and actually it isn't any good for us in a professional body or a regulator to say, well, we've done that, please look at the guidance if it isn't maintained and it isn't current and relevant. And for what it's worth, I mean, our legal team are also of the view there isn't likely to be any further action on this legal action. Obviously, we're out of time for an appeal to the Supreme Court. But I think, as a lot of commentators have said, this isn't so much about the failings of the law. It's kind of shown up some holes in the regulatory arrangements. So actually, if this is going to be revisited, it's going to have to be revisited in terms of the entirety of legal regulation, which is a kind of once every 25 years type job. Although, of course, the Act is getting on in terms of years.
Yeah, 19 years old, isn't it?
It is. So I think it's been quite a journey, but a right result and a good result. It was 3 really intense days in the Court of Appeal. You know, with
and how was it being in the Court of Appeal? Did it feel quite, I don't know, there's something quite special about it, isn't there?
Absolutely, yeah. I mean, it felt pretty intense, actually, as you'd expect. I mean, the panel was chaired by Master of the Rolls, Sir Geoffrey Voss, and you know, these individuals, as well as having brains the size of planets, take no prisoners, and they know what they want clarification on. They've read all the submissions. I'll be honest. I mean, I've only been to the Court of Appeal 2 or 3 times, but on that first day when our KCs opened with our submissions, I felt it was going badly, because actually the Master of the Rolls jumped in and said, Mr. Bacon, I understand the bits, like some of the history that I've just gone through.
Yes.
But he had some very specific questions that were thrown out, and it was almost, well, it was an interrogation that first afternoon. And I thought, well, that's either because the panel of 3 was so on top of the submissions and had just decided those specific things they wanted to know, or they didn't think much of it and they were going to pick some holes in it. But actually, I needn't have worried. I mean, I guess we were quite lucky actually with that panel, because Geoffrey Voss, I mean, he was chairman of the bar when the Legal Services Act was introduced in 2007. He had been on the Bar Council all through the development of the bill that became the Act. And of course, in practice, and this came out in some of the comments he made in the court, you know, in a sense, he'd grown up in practice in his professional life, working with managing clerks, CILEX members, other unqualified people supporting the work that he was doing too, or the solicitors with whom he worked. So actually we were quite lucky there, I think, that someone understood from a practical point of view what roles people had. We were lucky. I mean, Nick Bacon, KC, you know, former member of the Civil Procedure Rules Committee, knows was very tuned into a lot of the judicial concerns about what happened in the first Mazur judgment. Ian Miller, I mean, he's one of the most experienced regulatory lawyers around. He's the general editor of Cordery on Legal Services, which is kind of the go-to Bible for solicitors and others in the sector, actually, for many of the issues that arose in the case. Stephen Nelson, former in-house counsel at the SRA. So in terms of the team we had and the people we were before, we were quite lucky because they were so completely immersed in and understood the detail. But it was hard work. I mean, after each day, there were those sort of evenings where there were conferences and then overnight work to sort of prepare based on what we had come up during the day. But incredibly exciting stuff, actually, to see the law in action like that. Obviously, I feel a bit more rosy because it was the right result for us. But
yes.
it was exhilarating stuff, and you really at the sharp end of the law doing its business. It was fantastic. I'll stop there actually because I could ramble on.
Brilliant. No, that's fantastic. Thank you. Because I think understanding kind of the practical realities of being in a court and that interrogation, I think it's really good for students to understand that even when you're at that level and you're a KC, you know, you are being challenged and you really have to know your stuff. And it's, you know, you can sort of feel the tension in the air, can't you?
Absolutely. And I think the Law Society team in particular, I mean, they're professionals, so you don't take things personally, but they clearly felt they had a rough ride because obviously at our side's prompting, the sort of inconsistencies or even worse, the apparent sort of changing of direction during the submissions, the court just jumped on, and it was brutal actually, but then that's what you expect. I mean, when you're at that level, you've really got to be on your mettle and be prepared to counter anything that panel of judges throws at you. So it was quite amazing to watch actually, and any shortcomings they're straight onto.
Oh, Simon, you've just muted your mic by mistake.
I wonder how I did. I don't know how I did that. Shouting at the buttons, probably. Yeah, the Legal Services Board's counsel was very effective, actually, and opened by saying that the LSB were in a unique position as an oversight regulator. They could see what the other submissions were, they could see the history. Part of their role is sort of performance review of regulators and so on and so forth. So they're uniquely placed to bring their perspective and clarity. and then went on for 15 minutes to add layers of confusion. And when the MR, in a frustrated tone, said, "Mr. So-and-so, I need to ask you some very specific questions. What is your view on X?" He had to say, "Well, I've been specifically instructed not to respond to that point, my lord." So again, if you're a lawyer, you've got to be on your mettle, but you're also at the limit of the instructions that you're given by your client as well. And that was the most dramatic way that was brought out that I've seen, actually.
Well, that's interesting for students to know that you are acting on your client's instructions, and you have to deal with that, whatever those instructions are, and that can be sometimes quite challenging as a lawyer, but that's part of the role of being a lawyer, isn't it? You are the mouthpiece for your client in that regard. Thank you, Simon, for sharing that with us. That's really fascinating, really interesting. We've got a couple of questions that I think Simon C might be able to answer as well, and maybe you also can answer some of this as well. So Simon, I've had a question from Miriam about, you talked about work experience. Does that need to be specifically within a law firm? Could it be in a local authority, legal department, which is something that Simon's already alluded to, or something else? So could you just give us a little sense about work experience and what that means in terms of what you're requiring?
No problem at all. Great question, Miriam, first of all. So yeah, definitely it could be in a local authority. In actual fact, we are very attuned to local authority lawyers as well, local authority legal teams. And in terms of the pathways, they will take into account the sort of work that is done within local authority legal teams, because we recognise it's so far removed from private practice. So if you look at family law in the context of local authorities, public law, family, and what have you, it's very, very different from private practice. So absolutely, yeah, no problem at all. Certainly, to anybody else, I mean, don't imagine that it needs to be in a traditional legal firm. Very often we've got people working in-house legal teams for retail organizations and sort of tech companies and what have you. Very often that's where we've seen pretty much exponential growth, actually, is those in-house legal teams, because legal services are very, very expensive for businesses. So it makes sense for them to develop their own staff, their own legal teams. So if you are seeking employment, don't just gravitate to the traditional law firms. Do look at places like local authorities, for example. Do look at places like government agencies, and that's going to segue nicely into the question for Paris as well.
Yes.
So,
So Paris says, I finished my law degree this year through the academic route, struggling to find a job to move to which specialises in criminal law, especially as a starter, as most ask for previous experience. Am I best to wait starting CILEX until I've found a suitable role? Are there any suggestions as to where to look for volunteering roles that would assist? They currently work as a police staff in the control room, but where that won't assist much with the practical side. Although that is fantastic experience, Paris. I'm sure you are getting an incredible insight through that work.
Absolutely. And if it's the criminal law field that you're looking at, we would definitely say, Crown Prosecution Service, certainly, because, we do an awful lot of work with the CPS. We're very known to the CPS. They have apprenticeships through ourselves as well. So, and I'm just going to highlight the work of Simon's team on which bill was it, Simon, as well, for the now enabled CILEX?
Victims and Courts Bill. Yeah.
Victims and Courts Bill. So Simon is our director of policy, and is very much about his team's work is very much about lobbying for legislatory change that furthers the ability for CILEX trained professionals to operate without barriers. So yeah, certainly Paris on that one as well. So CPS would be a great opportunity. As you've mentioned, experience is absolutely key. That work experience doesn't need to be paid as well. I mean, if anybody wants to do voluntary work experience, that will count as well towards qualifying experience as well. So I hope that helps anyway.
Fantastic. And if anybody's got any other questions, please, we've got we're in our last couple of minutes. If anybody got any final questions, please do pop them in there. But I hope what today has given you is a kind of really kind of good sense that there is this other opportunity, because often people don't think about CILEX in the same kind of way, or they've not heard of it before. And this gives you a really great opportunity to think about another route. And so I would suggest, Simon, would you, that they check out your website, have a look at that, have a look at the slides, and you are kind of living proof as an OU student of this journey, aren't you?
Absolutely. Absolutely.
Yeah.
I mean, it was CILEX that actually kept me on my path as well. So I was, you know, an OU career day, and my marks had dipped a little bit because work had got in the way, and I was considering chopping it all in, taking my credit and running for a psychology degree instead. But it was actually recognising there was another route into the sector that actually kept me on, and you definitely can pull your marks back. As well. So.
And Marcus is, I think we'll give Marcus our last question. CILEX seems more designed for those already working in or around law. How does that apply to career changes? And imagine passing SQE 1 or 2 is more attractive in terms of recruitment. Would you say that? I'm not necessarily sure that is necessarily the case.
Not necessarily the case, no, because I mean, you'll find a lot of employers know that somebody that's gone through SQE, they'll be well versed in all the different areas of law, but they may not necessarily have that specialist knowledge. So so very often people that have been working through CILEX will have that specialist knowledge. So they will be well versed in a particular area of law, and that's really what clients want. You know, I mean, the analogy I give is, if my boiler breaks down, do I call a heating engineer or a handyman? Now, handyman can put up a shelf while he's here, but you know, realistically, I want to put my confidence in somebody who's got the credentials for that particular area that I want those services in. So so there we go. I mean, it's just a question of, like I say, I mean, solicitors, CILEX lawyers nowadays, if you look at, you know, the rates that they charge for hour, they're exactly the same, so that gives you an idea of how the industry views them as well.
Yeah, and I think a lot of it's depending on the type of area of law you want to look at, looking at the opportunities within in those areas of law, because there will be differences depending which kind of firms you want to go to, which opportunities there. So I would just say, keep this in the mix, and then think about all the different opportunities, and before you make a decision. And I think, I think I just saw this flashing out, but Carleen said that thank you so much. She did not see this as another route. So exactly what this is. This is another route for students to look at. So please do have a look at that. So just want to say a final thank you to Simon and to Simon for coming along today. It's been really, really interesting. It's fantastic always to have an OU graduate come back and talk to us. And I know, really thank you, Simon, because you come back every year, and that we're really, really grateful. And also it's really grateful to hear the work that you've done as an organisation to protect CILEX and to protect this other route, which is really important. And I think that's the work that you've done, Simon G, through the Mazur judgment. And really great to have conversations around supervision, because that impacts students going into law firms. The quality of your supervision, having been a trainee solicitor and gone through that route, is really, really important. So I think if we are having conversations around supervision, that's a really, really good thing. And that'd be really great for our students who are going to go and work in law firms in different ways. So thank you so much for your time today. And thanks to all the students who came along. We're really grateful. And we'll be putting up the recording and sharing the slides shortly. So thanks very much, and have a lovely rest of the day. And if it's sunny where you are, enjoy the sunshine, and long may it last.
Thanks, everyone.
Thank you.
Thank
Nice
you.
to see you all.
Take care.
Bye.
Thanks. Thank you so much.